And just so you guys know, I'm also sending this over to TrueTube as well. Thank you, Joe. Look, I mean, the fiddling with the mask. And I mean, look at the edges of that damn thing. I mean, you drive a fucking freight train through the edges of his mask. And I've got my volume completely muted and changed to a different microphone for WebEx, so there's no.
I don't have any audio over here.
Yeah, there's no audio coming through it right now. It's digitally dead.
So you had to switch and get a different microphone to be able to bring in their audio.
No, so basically what I've got is in their microphone controls, in their speaker controls. So like if I test it, right, and we'll hear people coming in with the boom, and that's just so I can make sure that you know, that everybody can hear it. Yeah, we have no audio right now. It's completely dead. And Eric's just staring at the screen.
Okay, guys. So we got a new channel coming. The idea is we're going to put all things Brent related. It's free Eric Brandt at YouTube. We'll be able to go live tomorrow. Apparently, it's not verifying. Um, thank you. I don't know how we were able to get into this call
That was
because that was on.
BB8.
Thank
Holy
you,
shit.
BBA. Better.
It looks like he's in the damn kitchen.
Hey guys, don't forget we got TrueTube.live. If anything ever happens to our YouTube channels, we will be over there for sure. We're actually streaming there right now as well as on YouTube. Soon to be streaming on Facebook as well.
Okay.
Okay, so I've got this. I'll push this to my other channel. I think it's working. We can add additional channels if you would like.
We've got up to 8, so that we can go live with on this day.
I just added my podcast up there.
Sweet. I just got the notification it went live.
Thank you. I appreciate that.
What are you trying to get into, Lacey? Into the WebEx? If you are trying to get into the WebEx, just go to webex.com, type in that code, and it'll download a program for you, and then you type in that code, and it'll connect you just like I am. And thank you very much to Baba or 22 whatever. Sorry, I'm screwing your name up, but there you go.
I know
Thank
what
you.
I'm hearing. I'm hearing it on my WebEx in the background.
Are you hearing someone? They're talking?
Yeah, I have video and audio on my WebEx on the computer. Only have video on the phone.
There. Hi there. We have a user named Tom who joined. Are you just here observing?
On the computer. Only video on the phone.
Oh, okay. You're the same user that called in. Okay, I've gone ahead and muted you.
Are you getting more audio than that, Pikes?
Yeah, I mean, are you in Michael Steinberg?
I just connected to the meeting that was there. I'm connected to 922-520-016.
I'm in Tamara Russell.
I'm in Chris Munch's personal room.
Okay, so the Stephanie London's got the correct code up there right now?
That's the one we're currently in, is the one that Stephanie gave us.
Okay, we back on the record here. All right, we're reconvening now in cases 20 CR 358, 19M 4727, 19M 4726, and 19M 2687. With us?
I am, Your Honor. Things seem to have quieted down.
All right. Was there anything else that you wanted to say before I gave Mr. Brandt a chance to say whatever he had in his mind?
Court, I'd like the court to first give Mr. Brand a chance, and then if you could come back to me briefly.
Yeah. Yeah, Your Honor, I wanted to just address, fill in some gaps on the conversation that Mr. Kelland and Mr. Greenblatt and you had. And I might have to remind myself what we were just talking about. Apparently my mind took a break too. First of all, the felony cases in Denver. The one pending, the case that's still pending, that's for Cassandra McKinsey is the counsel on that case. And I can tell you that she's told me that she's received over like 3,000 pages of discovery in that case. And she's received so much voluminous files on Blu-ray discs that she's trying to figure out how to get that converted to a form that she can come and view that with me. And because they don't have that capacity here. And if we're going to be reaching a global disposition, then obviously I don't think I hadn't had that conversation with Mr. Kelland, so he wouldn't have known that. But I would anticipate if they're feeding her with 3,000 pages of discovery from the other cases as well, that you're probably going to receive a similar inundation. As to the felony case in Denver, that was a case that should not have been brought. It was absolutely a malicious prosecution, but sometimes justice is a fruit that comes in many flavors. And the charge on that was felony assault on a peace officer. They knew 6 months ago that that didn't exist, and they added the charge of harassment. And that's the case that had a $100,000 cash only bond. It was causing me a tremendous amount of injury. It's the only violent case that I have there. And so since that was being kicked down the road for probably another 6 months, I had to stop the bleeding on that. So I took an Alford plea in that case for a harassment by obscene gesture. So obviously there was no obscene gesture involved, but if they were giving me harassment by obscene gesture, that means that there was never a violent assault on a police officer either. So that hopefully fills in a little bit of the gap as far as the questions that the holes that were left in the conversation that you guys had. I just wanted to fill that in. Oh, there. I can't hear you, Judge. There you go.
Can you hear me now?
I can.
All right. Ms. McKenzie is the lawyer on the case that is still going on in Denver, or the one that already resolved?
Christian Griffin was the attorney on the case that just resolved. Cassandra McKenzie is the one in the case that's still pending. And I'll also say Christian Griffin was the one that handled the case on the diversion case. I don't know if he'll be reappointed, but we won't know anything more about that till Friday, I guess.
All right. Don't answer this question for a second, because I want to give your lawyer on your felony case here the chance to consider whether he wants you to answer it. Counsel, do you mind if I ask your client what the charge is on the currently existing Denver case? Because candidly, it sounds to me like many of us in this courtroom don't know anything about it.
Judge, I actually spoke to Mr. Greenblatt about this. My understanding is that we believe it was a retaliation against a judge case. Eric, is that correct?
That's correct. They're basically all the same case.
Okay, that's and you say there's like 3,000 pages of discovery on the Denver case. Counsel, do you know what level of felony is charged there?
Judge, I believe it's an F4, but I'm not sure.
I would, yeah.
Sorry, I can't tell the court that I've been in email contact with the attorney on that case.
Okay. Okay.
And so we can continue to coordinate any of those efforts.
Okay. Well, let me just start then. Oh, Ms. Poland, you wanted to be heard again after Mr. Brandt spoke. What was it you want to say?
Your Honor, I do. And if I'm speaking too loudly, please signal me. I've got my headphones on. I can hear much better with them on. Okay. Judge, I want to get Mr. Brandt out of the Jefferson County detention facility, at least on the 3 cases that I have some control over. There is a significant COVID epidemic there. It's my understanding that as many as 23 of the now remaining inmates have tested positive. And I put it in those words, Judge, because I know from other cases, a lot of the pods have been cleared of the non-violent offenders. It's my understanding there was a communication between Chief Judge Pilkington and the district attorney that they were going to make every reasonable effort to clear the jail of those offenders who did not pose a significant risk to the public. And I certainly think that Mr. Brandt falls under that category. I'm showing Judge a bond for $5,000, $5,000, and $1,000. Now I understand he still has the felony case to deal with, and that matter will come up for maybe for a bond reduction later this week or early next. But Your Honor, my inclination would be to ask that Mr. Brandt receive a personal recognizance bond on all 3 of those cases. He's got almost 6 months in custody on the case that he was convicted of the jury, which was an M2 and an M3.
Actually, it's just an M2.
An M2.
Those 2 are going to
M2.
those 2 are going to. You don't know yet, but those 2 are going to merge.
Okay. All right.
The 2 and the 3 are going to merge.
So my feeling is we've got Mr. Brandt has some significant health issues that I think make him more vulnerable to this virus. It just seems to me, in light of the mood, both in the judiciary as well as in the prosecution's office, he would be a prime candidate for release, reasonable bond. I can assure the court, we get the fact that the Lakewood Police Department wants to silence Mr. Brandt. We've got the message loud and clear. The court received 3 communications from them. they could not have made their position clearer. Mr. Brandt will comply with any reasonable request that the court imposes on him, be it house release, GPS monitoring, stay away from law enforcement unless it's absolutely essential. But he needs to get out of custody, Judge. I think it would be a tragedy if he were to contract this virus and some horrible result would occur, given the conditions that currently exist.
All right, the first thing I want to deal with is this request for a bond hearing. I'm going to grant it, but it's not going to be next week. Let me tell you what my concerns are, and frankly, I could use some help from the lawyers on this. It seems to me that what is probably driving this bus at this stage of the game is probably are the two Adams County cases. One is a revocation of a deferred. The other is a case where the highest offense is charged as a Class 3 felony, which is the most serious thing that Mr. Brandt is looking at. If Mr. Brandt, do you, and I take it that the sentencing, not only the sentencing hasn't been set, they haven't actually had a hearing where he's been advised on his right to a revocation hearing, right?
That's correct, Judge. And I can give the court just a little bit more information, especially as it relates to bonds in the Adams County case.
Yeah.
I looked this morning. It appears in the deferred judgment revocation case that he has already been granted a personal recognizance bond. It also appears in the 20 CR 19 case. Mr. Brandt originally had a $20,000 cash or surety bond that had been posted through a surety. When
in the Adams County case?
In the Adams County case. When Mr. Brandt was not transported from Jefferson County to Adams County for that first appearance, the court revoked that bond. Our intention is to request that bond be reinstated with consent of surety. My understanding is that Mr. Brandt has a long time existing relationship with the bonds person in that case, and that they are willing to provide that consent. I can't guarantee that the Adams County Court is going to accept that and reinstate Mr. Brandt on bond, but for the court's knowledge, as far as those two cases go, one appears to be a PR bond, and the other one, I think there is a realistic possibility that it becomes reinstated. At that point, I believe the largest single bond that he has on any of his cases would be the one that I'm here on today, the 20 CR 358 at 50,000 cash.
At what?
50,000 cash.
Oh, I thought it's 50,000. It was 20,000.
I thought
I could be wrong.
5,000. I believe here we are at 35,000 if I'm not mistaken.
And Judge, I can pull it up real quick and clarify it. I thought it was higher in this case.
Counsel, but both of you might be right. I had a bond hearing on it, and I denied a request to modify bond several months ago. I didn't think it was 50, but
it's 35.
35. Mr. Brandt's right. It's 35,000.
I apologize.
Yeah. Okay. All right. Here's the situation. Then I'm gonna. Well, first, you all have indicated you'd like to have what basically, I guess, is I don't know, it's a pre-trial conference or just some sort of a status hearing in early June. That request is going to be granted. I'm going to take up bond at that time. And candidly, it will be helpful to me at that stage of the game if I can get a report from you all as to what the situation is in Denver and in Adams County. Let's see whether or not the judge in Adams County agrees to reinstate that bond on the Class 3 felony. That would make a difference to me in terms of what I'm going to do on this $35,000 bond. But I will hear from you again, despite, it's true that I already had a bond hearing, but the situation is different, largely because of the COVID virus, and I'm going to hear it again. So let's first take a look at our calendars and come up with a date in the first 2 weeks of June and see if we can all clear our calendars for that. And will that give you time to do some more evaluation of whether or not a big disposition is going to be in the works? Is that enough time for you guys?
Judge, for speaking for us on this Jefferson County case, yes, I think that's enough time. I believe that's also enough time for the 2 Adams cases, that one that I'm on, one that I will be entering on.
You don't know about Denver yet?
I don't know about Denver, and I don't know if it gives enough time for the district attorney's office. I think it should, but as far as I'm concerned, yes, Judge. You know, anytime in June.
Let's go ahead and do it anyway then.
And Your Honor, I can be available June 1st, that Monday.
I can as well, Your Honor.
I was looking at June 8th, but I think I could make June 1st
Judge,
work.
candidly, I was looking at the 8th also, especially if we're going to rope in a third jurisdiction to try and get this resolved, because I know that our VRA
I take it the 8th works for you?
Correct.
How does that look for you?
I'd rather do it on the 1st, Your Honor. We're already going to be pushing that out a whole other month, and they've got 2 fatalities in Jefferson County already. They've got 107 inmates on isolation.
Counsel?
Your Honor, I can be available June 8th in the afternoon. I will echo Mr. Brandt's concerns. I think that there is an ongoing concern, and I don't think that concern lessens the longer he's in the detention center. We would request as soon as possible, but I can be available the afternoon of the 8th.
Ms. Pullen, how does the 8th look for you?
I can do the afternoon, Your Honor.
Right now, before we set that into concrete, though, I want to look at toward the end of the week of June the 1st. I think June the 1st is, I'm sorry, I think I appreciate Mr. Brandt's position and the position of all the defense, but I think it's too soon to be in a position to know whether or not you guys have much of a deal, but I don't see how the weekend makes any difference. So would you both look at the 4th and 5th of June for me and see whether or not you can all be available then? It seems to me that the 4th or 5th are pretty much as good as the 8th.
Good.
Sorry, go ahead.
I can accept any morning setting on the 4th or the 5th. Yeah, we can for the felony and the misdemeanors.
Okay, how about you?
I can be available either of those days, Judge.
Mr. Pullen, could you look at the mornings of the 4th and 5th of June for me and see whether or not?
I can do the morning of the 5th, Judge.
All right, in that case, the request to set a bond hearing is granted. The request to set basically a status hearing is granted, and it will be on the 5th of June at, no, we need the morning, they said. 9-ish? How's that work? How's 9 o'clock work for you all?
That's fine, Judge.
All right,
Judge, I can be available anytime.
9 o'clock then on Friday, June the 5th. And counsel, I would assume that you will comply with the VRA and let the victims on all these cases know that we'll be hearing bond on all these cases on the 5th at 9 o'clock, right? Okay.
Will do, Judge. Judge, I would ask if we can have the request submitted in writing, just so we know what we are being asked to reply to and respond to. If it's just we're raising bond because of COVID.
No problem. Could you and Mr. Poland just coordinate a written motion for bond reduction so that the grounds are set forth in writing so that can be shared with the victims?
Yes, Judge. Yes, Judge.
And can you get that done within a week's time?
Sure. I believe so.
Okay.
Seems reasonable.
All right. Then I'll direct that a written motion for bond reduction be submitted within 1 week, and we'll hear it at 9 o'clock on the 5th. All right. Now,
Sorry, before we move on from that, do we know a physical location for that day? Here? Okay. Okay, thank you.
okay.
Your
Did you hear
Honor,
that?
sorry, I did not hear the reply.
She said we can't tell you for sure right now because we got to figure out what courtrooms are available, but she will email it to you in advance so that you'll know what courtroom. And for that, I have no problem doing it on WebEx. So Mr. Poland, it might be just as convenient for you to do it from your office.
Okay.
It's up to you. Right? I'm not ordering you to do it that way. Okay.
Right.
Now, next, Mr. Brandt waived his right to a speedy trial regarding the misdemeanors, but we postponed until now resetting the trials on those misdemeanors. Ms. Poland, does your client want me to again wait till the 5th before we reset those misdemeanors, or does he want me to reset them now?
Let's wait.
Judge, I would prefer to wait till the 5th if Mr. Brandt does not have an objection.
We might as well do it because I think they're currently set for the 2nd anyway, which we're obviously not going to do. So I would say we would just wait until the 5th.
All right. Well, Mr. Brandt, I want to remind you that regarding those misdemeanors, you indicated, counsel, you all can correct me if I'm wrong, but I think last time we were here, you asked me to reset those anyway, and you waived your right to a speedy trial. But am I right about that?
No, you're correct, Judge.
Okay. Then, that request, well, does prosecution want to be heard on that request?
No,
That request is granted, and we will reset the trials on the 2 misdemeanor cases on June the 5th. Now, regarding sentencing, Mr. Pullen, I'm not sure you've had a chance to even review the Russell case yet, because it was just last week. Do you want to review that before you and talk to your client before you decide whether he wants to request? See, originally he wanted to be sentenced promptly. I think first coronavirus hit, and second, I think you at one point had the chance to talk to him about the status of the law, and he indicated he wanted to continue at first because he wanted some of his supporters to be able to be present, not just by writing me letters, but also in person. And also, I think he took your advice into consideration. Do you want me to postpone resetting the sentencing until the 5th, or do you want me to go ahead and reset that now?
Let's just do it all on the 5th.
I agree.
Let's reset.
It sounds like both of you would requested to be on the 5th.
Yes.
And let me just tell the prosecutors, I appreciate that you also have a right to have the sentencing get going. I don't think there's a serious prejudice if we reset it on the 5th, but I'll let you all be heard on that if you want to be heard on that question.
People are prepared to proceed whenever.
All right. In that case, on the 5th, we will reset the sentencing on the misdemeanor conviction. We'll set the trials on those dates. We'll see where we stand with respect to the felony.
And
Counsel, I think that what?
Can I ask
Mr. Brandt? Oh yeah, Mr. Brandt, go ahead. You want to say something else?
I just, before we break up here, I'd like to ask Mr. Kelland if he can come over to the jail and ask him to come get some exhibits from me, please, that I need you to have in paper form.
Did you hear that?
I can't. And Eric, I'll swing by the jail this afternoon to drop off the non-PDF discovery, and assuming it's ready, I'll grab it then, or I can come back later in the week. You and I can talk about that.
I'll tell my pod deputy that I need to send it down there. I don't know if they'll wait till you get here to bring it down or not, but I'm going to remind them that I have paperwork for you.
Okay.
Thank
all
you.
Right, counsel, that's pretty much all that I had on my plate. I appreciate you all getting on top of this because, frankly, I think that's kind of pretty important. Is there anything else that you all wanted me to take up today while we're on the record today?
Nothing else from the defense, Judge.
Oh, Judge.
The only thing from the people on the felony case, I did file a notice of intent for other act evidence. I don't know if the court wants to address that on the 5th once we kind of know a better idea of which way we're headed, or if the court just wants to table that until after the 5th and we know kind of a better which direction we're going.
My inclination is on the 5th, we'll know whether we're going to trial. Right now, the trial is set for July 7th. If we're going to trial on July 7th, I'm going to set a relatively prompt motions hearing date. We'll take up that motion at the same. There's also, I believe, at least one defense motion, if I remember right, on the felony. But I'm not sure that.
I don't think I'd seen it.
That's those are the misdemeanors. I got some motions on the misdemeanors.
Judge, I agree with Mr. Greenblatt. I think we'll have a much better idea on the 5th, and I think we can address those or set any dates at that point that we need to.
Then on the 5th, if it appears that we're going to trial on July 7th, I will set a motions hearing date. We'll take up your motion and any other motions that are promptly filed on the, on the motions hearing date. So that's it from the felony lawyers. Regarding the misdemeanor lawyers, Mr. Paulin, anything you want to take up while we were here?
I think we've covered it all, Judge. Thank you.
Prosecutors?
That's from the people.
All right, then let's just quickly review. We will postpone until 9 o'clock on the 5th of June, hearing the application for a bond reduction, which is going to be filed within 1 week's time. We, at that point, will take up whether or not we need to set a motions hearing date on the felony charge. We will reset the trials on the 2 misdemeanors that haven't gone to trial, and we will set sentencing on the misdemeanor that resulted in a conviction. Now, I didn't mean to shortstop you all. You may take the view that these two don't merge. I think I understand your argument is that one isn't the lesser included of the other because the couple of mental state on the lesser is more serious than the couple of mental state on the greater. I think that's your position. I'll certainly hear your argument. I've got to tell you, as I probably did, I am inclined to think that they do merge, notwithstanding that, but I haven't heard your argument yet, and I'm not foreclosing hearing your argument on that. But it's my, no, but we'll see where we are, and I will give you the opportunity to argue that at or before sentencing. And with that, I think, unless anybody else has anything else for the good of the order, I think we're done for today.
I'll try and call you, Mr. Poland, in about a half an hour.
That'd be fine.
All right. Thank you all, and we'll be in recess.
Thank you, Judge.
Now,
Red X.
just hit a find a red X.
Yep, there it is.
Right there.
Yep.
And leave meeting.
Yep.
Okay,
Wow.
well, that was very interesting, wasn't it? Does anybody have any opinions, questions, comments, and/or complaints about anything that you've just seen? If you don't, you must not have been paying very close attention. So they've been repeatedly asking to just be heard on motions to discuss the possibility of reducing some of these exuberant bonds, these outrageous extortion fines and fees that are being levied upon a poor homeless man for words critical of a system that every day is showing us again how fucked up things really are. Holy shit.
I have a request over in my chat to translate what happened for us.
Basically, they left.
Okay,
To me, they just left his ass in there and said, "We're gonna push this shit out to the 5th of June," right? Which is what, 12 days?
Your mic is low, bro.
Is my mic low? Well,
Your mic is low.
how about this? Did that help?
Perfect.
Much better.
My bad, guys. To me, they're just, the speedy was completely lost. They're pushing this to the 5th of June. It's the 18th, right? Which is what, 2 weeks, right? I'm pretty sure I was just hearing the judge tell the prosecutor he's going to combine them, even though the arguments are there, but
So
I don't see them helping.
There's they never help. Let's get that straight first of all.
Right.
There's a lot of underlying issues that we just witnessed there. If you're not familiar with the entire story, you would be lost in the intricacies. So Eric is waiting for sentencing from this judge. Before the COVID thing, he asked for prompt sentencing, and they've pushed it off now for several months. They're blaming COVID. Obviously, they don't have any problem holding court. They do have a problem getting it out there so that everybody can see it. But that's a whole nother issue. Actually, COVID, I think, is going to be a good thing, at least for courtroom transparency. It's pushing a lot of people of jurisdictions to broadcast that shit. So if they're doing it now, there's no reason for them to stop in the future. So they're trying